Good afternoon, RANM members. I'm Ashley Strauss-Martin, General Counsel for the Realtors Association of New Mexico, and I'm here to talk to you today about some changes to RANM Form 2104, the purchase agreement for residential resale. Additional changes will be addressed in Part 2 of this video. First, on cover page 2 of the broker duties under Section 2, a listing broker indicates how he or she is working with the seller, with a written agreement either as an agent or as a transaction broker. Now, the broker can indicate if he or she does not have a listing agreement with the seller, but does have a compensation agreement. This was added to address the scenario where a buyer and seller have found each other and wish for you, the broker, to simply assist them with the drafting of the paperwork. This box would be marked if you had not entered into a listing agreement with the seller, but the seller had agreed in writing to compensate you through some other compensation agreement. RANM is currently working on a form for this scenario, which should be out by the end of the year. But currently, the only forms for compensation in the RANM library are the exclusive listing agreement, the buyer-broker agreement, and the compensation on unlisted property agreement. All these forms would require some modification for use in this scenario. In paragraph 2 of the purchase agreement, we've added check boxes next to cash and loan amount that allows the parties to leave those spaces blank and simply indicate that the lender or the buyer will determine those amounts at a future date. In paragraph 3, we've added a new section and concept entitled Time Off Market Fee. This is a fee that goes directly from the buyer to the seller to compensate the seller for taking his or her property off the market for a period of time to enable the buyer to conduct his or her inspections and review the seller's property disclosure statement. As a result of this new concept, there were some minor changes made to paragraph 4, the earnest money paragraph, but more on all that in part 2 of the video. In paragraph 8C, the appraisal paragraph, we currently have some awkward language regarding buyer's right and privilege to continue with the sale if the appraisal comes in below the purchase price. It also references a statement from the Federal Fair Housing Commission. This language was all taken from the FHA loan required amendatory clause. RANM originally put the language in the form with the belief that in the event the buyer was getting an FHA VA loan, this language would eliminate the need for the parties to sign a standalone amendatory clause addendum. However, lenders are still requiring the mandatory addendum to be signed, even though the exact language is already present in our purchase agreement. Consequently, we've decided to take out the additional language, as it's awkward and serves no real purpose. Of course, the appraisal contingency remains. In paragraph 9, the closing paragraph, there's been some clarification regarding the settlement signing date and funding date requirements, and some reformatting of those sections. However, the paragraphs function as they always have. In paragraph 11, the cost to be paid grid, there are two major changes. First, note the bold, all caps language at the top of the page. There have been numerous instances where buyer's brokers have entered into the grid that seller will provide some seller concession or credit to the buyer at closing. Because this is a cost to be paid section of the purchase agreement, listing brokers and sellers have neglected to notice the seller concession language in this section, which, needless to say, creates a conflict between the parties when the seller discovers it after accepting the offer. Broker duties require the exercise of reasonable care, and placing seller concession language in this section of the purchase agreement where it can easily be overlooked is arguably not exercising reasonable care. We want all parties to the contract on the same page, and the best way to do this is to make additions to the contract, such as seller concessions or credits, as conspicuous as possible. It belongs on an addendum, not in this section of the contract. The second addition is found in the title policy fee section. Some language in the new regulations promulgated by the Superintendent of Insurance has led some title companies to charge an additional $100 fee for every change to the original title commitment, no matter how small. Consequently, it is important that brokers do their best to provide accurate information to the title company from the start. Again, things as small as a new spelling of a name could result in an additional charge. The new language in this grid states that the party who creates the need for a new commitment must bear the cost of any issuance, and if the need arises as a result of a survey or some other third-party document, and not as a result of anything either party did wrong, then the fee will be split equally between the parties. For more information on this topic, visit my Random Voice article from the last quarter. In paragraph 21H, which addresses buyers' objections, there's been a significant change. Buyers no longer have to provide a copy of the inspection report when the buyer is terminating. The buyer must still provide a copy of the report when he or she's objecting and asking the seller to cure something, but again, not when the buyer is terminating. You ask why? Well, we're seeing more and more inspection reports with copyright protection language in them. This language often states that the reproduction or sharing of the report is an infringement on the inspector's copyright. Remember, sellers who end up with an inspection report have a duty to disclose to the next buyer the negative information on that report. This is why my friend Oliver Franscona, a real estate attorney from Colorado, used to say, "Seller, you don't want that report." In deciding how to share that information, a seller has two choices: share the inspection report in its entirety, or transfer the negative information in the report onto a seller disclosure. The problem with the former is the copyright infringement issue. The problem with the latter is that a seller may neglect to include some information because in the seller's opinion, the information is not material or relevant, whereas in the buyer's opinion, it may very well be material and relevant. However, with the elimination of the requirement to provide a copy of the report when the buyer opts to terminate, we eliminate at least some cases. If the buyer and seller cannot negotiate objections, sellers will still end up with prior inspection reports. In paragraph 22, we have added the service provider recommendations paragraph from the listing agreement, which states that if brokers recommend a builder, contractor, escrow company, etc. to the seller or buyer for any purpose, such recommendations shall be independently investigated and evaluated by the seller or buyer. In paragraph 25, the maintenance paragraph, we've added the following language. If utilities are on as of the date of acceptance, then the seller shall maintain utilities through possession date or the date otherwise stated in an occupancy agreement. In addition, we've added language that says that it is the buyer's responsibility to arrange for transfer of utilities into the buyer's name on the possession date or date otherwise stated in an occupancy agreement. In paragraph 29, we've added that the agreement applies and will be binding upon and enforceable against the parties and their respective heirs, successors, permitted, assigned, and estates. While absence of this language did not mean it was not enforceable against the parties' heirs and assigns, per a legal concept called equitable conversion, the lack of such language created enough questions that we thought it better to simply add it back in. Paragraph 36, brokers have been removed from the paragraph at the request of attorneys who defend brokers in claims utilizing the broker's E&O insurance. In the signature block, we have labeled an area, title of entity, and name of signatory for entity. If the buyer or seller is an entity such as a corporation, trust, or estate, the party signing for the entity would provide his or her name and his or her title, such as personal representative of the estate of John Doe or CEO of ABC Corporation. This concludes the summary of the smaller changes to Form 2104. Please view Part 2 of the 2104 changes that address the Time Off Market edition for more detail. These changes will be available in Instanet and Zip Forms on October 1st and in Dotloop on October 1st or shortly thereafter. If you have any questions about these changes, please contact me on the RANM Legal Hotline. Thank you and have a great day.